Welcome. My name is Roman Basie. I'm an attorney at law. I'm also a real estate broker. Today's topic is the Construction Lien Act. In today's topic, you're going to see I'll present half of the slides today, and my father, who is also an attorney and a CPA, will present the other half of the slides. Just to give you a little background as well so you understand our presentation and where I may be coming from. Since I'm a real estate broker, we own properties. We've owned properties since 1978. We manage them, we maintenance them, we invest, and we build. I see a lot of situations regarding liens in general, mortgage liens, judgment liens, and of course, today's topic, mechanics liens. And they're important for you as contractors to know what they are, how they're enforceable, what you need to do to make them enforceable. What are the definitions that go along with them? Do you have them? Do you have the right to have them? Those are all topics that I'm going to discuss in the first 30 minutes of today's lecture. So let's get started with the Construction Lien Act. The first section we're going to talk about is the title. And I think this is important that you know the statute and where it's at. And it's section 570.1101 of the Michigan Code. And what's important here is when you're looking things up or when you say to yourself, oh, I think I have a mechanics lien situation or I need to make sure something's enforceable, one of the easiest ways to find out the information you need to find is to go to the internet, search the code, but you've got to know the title so that you can find it or the section number. And of course, the title for you guys is the Construction Lien Act. Typing in the words Michigan, it's going to bring you right there. You're going to be able to read the sections that you need to know and understand. Plus have the forms. The forms for you, as you'll see at the end of the first 30 minutes, are in the Act itself. We're also going to go over section 102. Now I'm going to abbreviate the section numbers. So we're going to talk about 101, 102, 103, so on and so forth, instead of talking about all of the numbers in front of that. But 102 talks about the meanings of some of the words and phrases. So it's a very short section. We're not going to spend any time on that. So moving on slide 3. So let's take a look first now. We're on section 103 of the Act. Let's take a look at some of the definitions that are going to impact you as the contractor and to find out whether they're going to be acceptable for you. And the first one is actual physical improvement. Are you making an actual physical improvement to the property? And I found something interesting here. So it means an actual physical change or an alteration of the real estate as a result of the labor provided pursuant to a contract. Ladies and gentlemen, it's got to be pursuant to a contract. You're going to see a little later on that contract should be in writing in accordance with the Act. A lot of you are saying, well, Roman, sometimes I may have an oral contract with somebody. Whether that's enforceable or not may depend on the terms of that oral contract. But when it comes to mechanics liens in your state, the statute's very specific when it comes to the enforcement, especially of a residential lien, that it be pursuant to a contract, and we'll see later pursuant to a written contract. It's got to be done by a contractor, by a subcontractor, or a laborer, which is readily visible. The improvement has to be readily visible. I've got a little bit of a problem with that part of the definition. You as a contractor, what if you're doing something behind the walls? Or what if you're doing something up in the ceiling area? Do you have the right to file a mechanics lien based upon that language of the work being readily visible? So you have to be a little bit careful in terms of what type of contractor you are, what type of lien you're trying to file, and are you meeting the elements of the statute? I'm not saying that it doesn't. I'm just saying that you have to be careful. And I think depending upon what you're doing and the lien that you're seeking, if you look at this definition of actual physical improvement, you need to see whether what you're doing is fitting into that so you have the ability to file a mechanics lien. It does not include that labor which is provided in preparation of the change or the alteration of the property, such as surveying, boring and testing, architectural or engineering, or the preparation of other plans or drawings, And I thought about this when I was reading through the statute again, and I said to myself, well, I hired a contractor to build a house for me. And I gave that contractor some plans. And I said, look, I want you to flip these plans. I want the garage to be on the right side instead of the left side. I want you to flip the plan completely. So in the contractor's bid to me, part of the bid included the architectural work necessary to flip the garage to another side. It also included testing a southwest corner of my property for weakness. The property that we were building on, there happened to be some underground mines in the area, and there happened to be some shifting in some of the houses in the neighborhood. And so they wondered, should we do some extra testing for this southwest corner of your home? Remember, under the statute, soil boring and testing is not an actual physical improvement to the property. The drawings of the architect and the engineers, they're not physical improvements to the property. Those costs are not going to be eligible under the definitions that we see here. Also take a look at the definition of a contractor. It's a person who, pursuant to a contract with the owner or the tenant of the real property, provides an improvement to the property. We didn't put the word on here, co-lessee or tenant, but you're going to see that throughout the statute. If you look at the statute as we go through today, or you look at it after today's presentation, you're going to see on there the words lessee, co-lessee. So even a contract with the tenant is binding under a mechanics lien act, such as the one that you have here. Take a look at the definition. There's a lot of definitions, and I'm just highlighting a few of them. Take a look at the definition of improvement now. We said earlier in the second bullet point there, the actual physical improvement. And now we're looking at, well, what's the definition of an improvement? It's the result of the labor or the material provided by the contractor, the subcontractor, the supplier, or the laborer, including but not limited to other features as well. So know the definitions of an actual physical improvement. Know the definitions of a contractor. Are you falling under the terms of a contractor? Let's take a look at a couple other, I'm on slide 4. Let's take a look at a couple other additional definitions. A lien claimant. You're going to hear this term. Who is the claimant? It's the person having a right to the lien under the act. You yourselves may be the lien claimants. You're claiming the lien when you hear that terminology. Subcontractor. We all know what the definition of a subcontractor is, but let's look at the definition for you under the act. It's a person other than a laborer or supplier who, pursuant to the contract between himself or herself and a person other than the owner or lessee, performs any part of the contractor's contract for an improvement. So anyone performing a part under the direction of the contractor for the owner, who is not the owner or the tenant, falls under the definition of a subcontractor for terms of the mechanics lien. Okay. Let's take a look now. We're skipping ahead now to section 107. So now we've looked at some of the definitions. There's a lot more there. But we've looked at some of the definitions to say, what's a physical improvement? Who's a contractor? Who's a subcontractor? Where are we at with this? What's an improvement to the property? Let's take a look at construction lien generally and look at the definitions that we have for you. Each contractor, subcontractor, supplier, or laborer who provides an improvement to real property has a construction lien upon the interest of the owner or the lessee, the tenant, who contracted for improvement to the real property. Break that definition down just a little bit. It's an improvement to real property. If you don't know the distinction between real property and personal property, you need to know that because it's only for the real estate. It's the work that you're doing on the real estate. And it's for the owner or the lessee who contracted for the improvement. We're going to see a little later in another slide where, what about a co-owner or a co-tenant who didn't contract for the improvement? And you're going to see where they fall under this umbrella. You're going to catch them under this umbrella of the Mechanics Lien Act. We take a look at bullet point number 2. It's a construction lien acquired pursuant to this act. shall not exceed the amount of the lien claimant's contract, less payments made on the contract. What does that mean? You can only claim what you're owed on the contract, minus what you've already been paid. You can't claim above and beyond it. I'll give you an example. This isn't an example that dealt specifically with a mechanics lien, but it's an example of a contract constraint. Had a client call us. He's a defense contractor. Says to us, I've got someone, Roman, that owes me $30,000. What do I do? I said, okay, let's see the contract. Let me see the contract that you entered into with the owner. He sends us the contract. Lo and behold, the contract itself is only for maybe $10,000 or $15,000. I call the client. Why did you tell me he owed you $30,000? Well, Roman, I'm adding attorney's fees, court costs, other things on there. I said, whoa, whoa, whoa. I don't see that in the contract. If it's not in the contract, you may not be able to claim it. And specifically for you, under the statute of the Construction Lien Act, it must be in the contract. You cannot add other claims for attorney's fees, court costs, collection fees, unless they are in the contract. So I highly recommend all of you at the end of today's lecture, go back, take a look at your contract. What does it say? Does it lay out your job and what you're going to be paid for? Does it have an attorney's fees clause in it? Does it have a court cost clause? Does it have a collection clause? You want those in there, or your act specifically limits you to where you cannot collect.